By the end of this presentation, I feel very confident that you'll be aware of probably three things: that income tax is unlawful in Canada, in probably every province except Quebec. Tax is also for the benefit of the bankers, and the Government of Canada has no lawful authority to even exist. And throughout this presentation, I will undoubtedly be using the terms CCRA and Revenue Canada interchangeably, because CCRA is a recent change that was made, and Revenue Canada was its predecessor and the organization that I worked for. Today, that organization is known as Canada Customs and Revenue Agency, or CCRA. And during my career with Revenue Canada, I worked as an auditor, a collector, and a special investigator. It was during this period of time that I witnessed some acts and treatment of Canadians that caused me to literally become ill. I could not function in such an environment, and to be party to the types of things that I was required to do, I simply could not do that. I missed a lot of work as a result, and I was continuously at odds with my employer. What I have witnessed and learned since leaving Revenue Canada has simply confirmed the existence of a plan of genocide against the people of Canada by special interest groups that I will refer to as the oligarchy. Some refer to them as the international bankers. They exist, and they are attempting to subjugate the entire world to a one-world dictatorship known as the One World Government or the New World Order. This is a small group of families and individuals who work behind the scenes to control our government and manipulate its actions in order to commit genocide against the people of Canada. In addition to genocide, we're talking about theft of the wealth of all Canadians and the enslavement of all Canadians. My purpose in life at this time is to save my government from this maniacal oligarchy and once again gain control over the people's creation, which is the Government of Canada. I will state my position very clearly from the start, that our government is not the problem. They are but tools in the implementation of the oligarchs' plans to rule the entire world via the One World Government, or unelected dictatorship. If any of you think that you have nothing to worry about if you keep your hands clean, quote-unquote, and obey the law and pay your taxes, I have news for you. I will begin by relating an incident to you that is but the mere tip of the iceberg as regards such incidents across the country today. There are literally thousands of similar incidents, and there are many within CCRA, the successor of Revenue Canada, the federal tax collection agency, who are proud to have caused such devastation in the lives of Canadians. I speak with authority on this issue because I have been there and I know some of these people. Now let me turn to the topic of this discussion, and that is the history and evolution of taxation in Canada. I will not get too involved in the history preceding the year 1867, but suffice it to say that there is ample evidence to show that Britain was concerned that British North America, that is Canada, would fall into the hands of the Americans or some other foreign power, and therefore decided to cause or force the uniting of Upper and Lower Canada with a view to bringing the entire country together eventually. The evidence further discloses that the people did not want this union, particularly Nova Scotians who voted not to join in this confederation. However, despite all opposition, Britain finally passed and enacted the British North America Act and established a dictatorship under a dictator known as the Governor-General of Canada, who took advice from the Dominion Parliament. Therefore, it should be understood that Canada has never had a constitution. What we had was an act of the Imperial Parliament of Great Britain, and what we have now is the same document referred to as the Constitution Act of 1982. The BNA Act, currently the Constitution Act 1867 to 1982, allocated the powers of the two levels of government referred to as the legislatures, or provinces, and the Parliament, the federal government. These powers were defined and outlined in two separate sections of the BNA Act. First, there is Section 91, wherein the powers of the Parliament, or the federal government, were outlined. Then there is Section 92, wherein the powers of the legislatures, or provinces, are outlined. It is a recorded fact that Section 92 was written first, followed by Section 91, which in fact could have been left out because it is residual in nature. In other words, the provincial powers were listed first in Section 92, and the federal government or Parliament got the remainder. In the case Nova Scotia Attorney General versus Canada Attorney General, 1951, the Supreme Court of Canada, on October the 3rd, said this: "The Parliament of Canada and each provincial legislature is a sovereign body within its sphere, possessed of exclusive jurisdiction to legislate with regard to the subject matters assigned to it under Section 91 or Section 92, as the case may be. Neither is capable, therefore, of delegating to the other the powers with which it has been invested, nor of receiving from the other the powers with which the other has been vested." The court went on to say this: "The Parliament of Canada and the legislatures of the several provinces are sovereign within their sphere, defined by the British North America Act, but none of them has the unlimited capacity of an individual. They can exercise only the legislative powers respectively given to them by Sections 91 and 92 of the Act, and these powers must be found in either of these sections." The court went on to say the Constitution of Canada does not belong either to Parliament or to the legislatures. It belongs to the country, and it is there that the citizens of the country will find the protection of the rights to which they are entitled. It is part of that protection that Parliament can legislate only on the subject matters referred to it by Section 91, and that each province can legislate exclusively on the subject matters referred to it by Section 92. Now, this is the Supreme Court of Canada ruling of 1951. And what this means is that if either level of government has any power, it is granted them by either Sections 91 or 92 of the BNA Act, or what is referred to as the Constitution Act of today. It also means that if the provinces have a power such as direct taxation, then they cannot give this power to the federal government, as they have in every province in Canada except Quebec, which collects its own income tax. Thus, this means that income tax, even provincial tax, in all provinces except Quebec is illegal because of the tax collection agreements between the provinces and the federal government. Legal means written someplace. Unlawful means it does not have lawful authority. So the income tax of Canada does not have lawful authority, not sanctioned, therefore, by the so-called Constitution. The last paragraph means that we should be able to find protection in our so-called Constitution, but I'm afraid that we cannot. The courts are all currently operating under admiralty or maritime jurisdiction, meaning that when we enter the court, we are in a court-martial type of proceeding where we have no rights and there is no Constitution. This situation has been accomplished by the introduction of the Uniform Commercial Code, UCC, whose equivalent in Canada is the Bills of Exchange Act. The UCC is an international act which applies to the United States and many other countries. The Bills of Exchange Act in Canada is the equivalent, and it represents Roman law and can be traced back to Babylon. Therefore, we are under Roman law, and the courts are operating under admiralty jurisdiction, with the actual supreme law of the land being the Bills of Exchange Act, and suspension of the Constitution has therefore been accomplished. The Federal Income Tax Act was introduced in 1917. The express purpose, at least what Canadians were told the purpose was in order to pay the cost of the First World War. In subsequent parliamentary debates, the question was asked why we still have a federal income tax when the cost of the war was paid off in 1929. The question reveals that there is a hidden agenda, and that the Federal Income Tax Act has nothing to do with the express purpose for its introduction. The real reason the Federal Income Tax Act was introduced in 1917 was in order to service a national debt that was growing at enormous and unprecedented rates due to the introduction of the Bank Act of 1913. This act, either by acquiescence or by the statute itself, gave the power to create money and control credit to the private banks. This, too, in accordance with the Supreme Court decision of 1950, is ultra vires the powers of Parliament. I hope you can now see that the real problem is not your government, it is the money changers, the international bankers. You see, the purpose of taxation of all kinds, and even the courts and license fees, speeding tickets, and the like, parking tickets, is all designed to take the bank's unlawful and debauched fiat currency out of circulation and return it to its creator, the banks. Once you cut through all the smoke and mirrors, that is what you come up with. Some of you may find it rather unbelievable that the private banks actually create all of our money out of nothing, loaning it to us at interest, and we are required to pay this money and the interest back to the banks who created it. The overwhelming evidence of the truth of this statement is contained in the minutes of proceedings of the Standing Committee on Banking and Commerce held on March the 8th and 16th of 1939. Witnesses that were called during these proceedings were Dr. W.C. Clark, Deputy Minister of Finance, and Mr. Graham Ford Towers, Governor of the Bank of Canada. At one point, Mr. Towers was asked this question: Mr. Towers, when you allow the merchant banking system to issue bank deposits, which, with the practice of using the checks as we have it in vogue today, constitutes the medium of exchange upon which I think 95%, at that time there was a 5% reserve requirement which was eliminated by Mulrooney in 1991. Now the banks are required to have no reserves and are totally unlimited in the amount of money that they can create. I continue with the quote. I think 95% of our public and private business is transacted. You virtually allow the banks to issue an effective substitute for money, do you not? And Mr. Towers' answer is most revealing. He replied, the bank deposits are actually money in that sense, yes. This kind of exchange continues throughout 854 pages of minutes that I have in my possession. Therefore, I trust that you can see the relationship between taxation and the fiat currency money system that we have in existence today. If the government was issuing our money, as they are required to do by the Constitution Act, then we would have no taxation whatsoever at the federal level, other than taxation of corporations on the extraction and use of our natural resources, or our wealth. This wealth would then be turned over to us, minus that portion which the government used to provide the services to us that we authorized. Now let me discuss some more interesting facts. Let's talk about the government itself. I will not take you through the entire history of the government, simply enough to establish one fact. The government of Canada has no lawful authority to exist, and as such, it is a criminal organization, and will remain so until authorized by the people of Canada by their writing and acceptance of a constitution. The Government of Canada, aside from being a criminal organization having no lawful authority to exist, is nothing more than a puppet government operated by the oligarchy. Sir Charles Schuster, Clerk of the Crown in Chancery by warrant under the King's Sign Manual on the 23rd of March 1931, was the person who signed the last valid and lawful Canada Letters Patent under the Great Seal of the realm constituting the office of Governor-General and Commander-in-Chief of the Dominion of Canada. Canada was removed from colonial control by the Colonial Office of the Crown in Chancery, which removed the statutory power of the Clerk in Chancery to issue any more letters patent for the office of Canada's Governor-General. Prime Minister R.B. Bennett, on the 10th day of August 1935, by the command of His Majesty, an heir and successor to Queen Victoria, despite this heir and successor having been removed from the British North America Act of 1867, by the repeal of Section 2 of the said Statute Law Revision Act of 1893, and with the power of the Crown remaining in the Chancery in the United Kingdom, did thereby commit fraud against the Canadian people by signing a commission appointing the Right Honourable Lord Tweedsmuir to be Governor-General and Commander-in-Chief of our Dominion of Canada, with a continuance of all the powers and privileges of that office. Additionally, please understand that all public officials in Canada are in grave danger as the people of Canada become aware of the crimes committed against them by their government and the government officials. CCRA is a privatized criminal organization reporting directly to another NGO or non-governmental organization known as the IMF, the International Monetary Fund, who in turn receives its orders from the BAC, that is, the British American Commonwealth, who in turn receives its orders from the oligarchy, possibly with a few other intercessors along the way. CCRA is, therefore, another foreign criminal organization, and I, for one, refuse to comply with orders from such an organization. What can you expect if you take these issues to court? The issues of the unlawfulness, the lack of constitutional support, that is, for the Income Tax Act of Canada, the lack of constitutional support for provincial income taxes being transferred to the federal government, the issues concerning the banks controlling our money and issuing fiat currency out of nothing and enslaving us, and the fact that the government is an unlawful criminal organization, well, you can expect to lose. We must remember that there is no constitution in Canada for a variety of reasons, the main one being that it has been suspended by the introduction and adherence to the Bills of Exchange Act. When you enter a court, you are under Roman law and in an admiralty jurisdiction, meaning you are guilty until you are proven innocent, and the law is what the judge says it is. I would now like to just touch upon one of the cases, the only case really of any significance that the federal government uses in any situation that is brought before the courts, challenging the constitutionality of income tax. And it's the Karen case. And I'd like to just mention that the Karen case is not really law, because it's the only case of any relevance that they use. I will deal with it, however. This decision was also made by the Privy Council, the highest court of appeal in Canada at the time, that is 1924. This court was abandoned in 1949 in favor of the Supreme Court of Canada being the highest appeal court in Canada. The Privy Council in the Karen v. King case of 1924, which was an appeal from the Supreme Court of Canada, the court appeared to have been under pressure to satisfy the need for revenues by the Government of Canada as a result of Canada's immense efforts in supporting the British government in the First World War of 1914-18. At least this is what the federal government touted as their justification in its argument at that time. Time has given us a much different picture on this claim. We now know that the real reason for the national debt is the fact that the federal government gave its money creation powers to the private chartered banks in 1913, and from that time borrowed itself into debt, being the only way they could raise revenues other than indirect taxation. Using this deceitful reason, the federal government implemented the controversial Income Tax Act of 1917. However, the public and the Privy Council ate it, hook, line, and sinker. It was for this reason that the Privy Council made the decision it made in the Karen case. It not only reversed itself from its numerous previous decisions on this subject, but in order to do so it broke one of the cardinal rules of statute interpretation. It added words to the Constitution. The court added the words "for Dominion purposes" in 3 places in the official court report, thus justifying the Government of Canada's right to continue imposing direct income taxation within a province. Regardless of the rationale used by the court to justify its decision, it was an irrational and unlawful decision. The court, by adding words not found in our so-called Constitution, simply violated the rules of statute interpretation and did something that they were simply not permitted to do, and that is make law. Additionally, the Supreme Court of Canada in the Lord Nelson Hotel case returned to reality when rendering its decision in 1951, and once again recognized the divisions of power and the watertight compartments, quote-unquote, thereof. The court even went so far as to quote from one of the decisions of the Privy Council that we use, namely the Bank of Toronto v. Lamb of 1887, when it said, "Their lordships adhere to that view," and held that, as regards direct taxation within the province to raise revenue for provincial purposes, that subject falls wholly within the jurisdiction of the provincial legislatures. I have provided overwhelming authoritative proof that income tax is currently structured in all provinces except Quebec is totally unlawful, and in accordance with subsection 52(1) of Schedule B of the Constitution Act, the Income Tax Act of Canada is of no force or effect, since it contravenes the Constitution Act. Thus, the Karen case is not valid law for the reasons that it used words not in the Constitution when making its decision, and it violated two legal maxims by ignoring its own decisions in 6 previous cases on this issue and failed to overturn them. Of course, I would like to take this opportunity to point out once again that Canada does not have a constitution. As proof, let's look at 2 different dictionary definitions of the word constitution. Osborne's Concise Law Dictionary states this: 1. Those laws, institutions, and customs which combine to create a system of government to which the community regulated by those laws accedes, and 2. The written document embodying those laws. Black's Law Dictionary defines constitution as this: the organic and fundamental law of a nation or state, which may be written or unwritten, establishing the character and conception of its government, laying the basic principles to which its internal life is to be conformed, organizing the government, and regulating, distributing, and limiting the functions of its different departments, and prescribing the extent and manner of the exercise of sovereign powers. A character of government deriving its whole authority from the governed, the written instrument agreed upon by the people of the Union. I don't know about you, but I have never been asked to vote on or have any input into our so-called Constitution. I would like to point out here that not only do we not have a Constitution, the Act of the Imperial Parliament of England that Trudeau so deceitfully repatriated and called a Constitution is being routinely violated by the federal government. The federal government has intruded upon provincial government powers in areas of taxation, subsection 92(2), property and civil rights, section 92, subsection 13, with the gun law as only one example, health care, section 92.7, with the National Health Care Natural Resources under section 92A with the National Energy Program, and the list goes on. Join us in our efforts. Support us by becoming a member of We the People of Canada organization by visiting our website at wethepeopleofcanada.com. Membership is free. Our purpose is to bring the people of Canada together in an effort to bring about the changes necessary to save our government and sever the chains of bondage that bind us to the international bankers. The present debauched monetary system being fiat currency created out of nothing by the private banks, the only purpose of which is to steal our wealth and enslave us all. What we have learned about the system of today is that they have managed to accomplish the prophecy by creating a mirror image of us all, and have, through several of the millions of laws the government has created, made merchandise out of us all. We are the collateral for the national debt. Our birth certificates are bought and sold, and our labor is hypothecated for the worthless pieces of paper, currency, that has enslaved us all. If you do not believe what I say, simply write your name in the manner that it was given to you by your parents. Your name is written with each name beginning with a capital letter followed by lowercase letters. This is the correct way and the way we were all taught in school. This is also supported by the Canadian Styles Manual, a government publication. Now look at the name on the province's driver's license. Who is that? It certainly cannot be you. What has happened is that the government has created a mirror image of you, and as such, they have taken control of you because you admit to being that legal fiction, the all-capital name, or some other variation of your real name. I have just brought this to your attention to let you know and to understand that something is going on and that we have figured it out. We now use their laws to our advantage. This can be accomplished by you as well. I leave you with this one very important thought about taxes and the debauched monetary system that we have today in Canada and all other countries of the world with the exception of the Islamic world. Taxes provide us with nothing. All taxes are used to return the worthless paper currency back to the banks who created it. Once we cut through the smoke and mirrors and get by the idea that government needs money to provide us with roads and health care and pay interest on the national debt, we come to the realization that taxes are simply a means of stealing our wealth and enslaving us all. Proof of this is contained in an understanding of this next statement. I said it earlier, but it bears repeating. The country and all its natural resources belong to the people. The government is our servant and our trustee. The government, being our trustee and manager of our natural resources, means that the government has all of our wealth, and therefore all of our money. It is all under their control as trustees. The government has been managing our natural resources for about 150 years now. When are they going to send us our money? You see, instead of us having to pay the government anything, they should be paying us each and every year, once they have used the amount that is necessary to provide the services that we have authorized them to provide to us. Since we have not received our wealth or money, then I would have to presume that someone has stolen mine. What do you think has happened to yours? I would hope that at this point you now realize that the Income Tax Act of Canada is an unlawful act, having no constitutional support. In fact, being ultra vires the powers of the federal government given to it by the Constitution. Additionally, the income tax of all 9 provinces, that is, except the province of Quebec, is also unlawful in accordance with the Supreme Court of Canada ruling of 1950 in the Lord Nelson Hotel case, in which it stated that the powers of one level of government could not be transferred to the other. Therefore, since the federal government collects the provincial taxes in all 9 provinces other than Quebec, that makes it also unlawful. In addition to that, I hope you understand now that income tax, all other taxes, the court fines, license fees, speeding tickets, offense fines of every sort in this country are for the benefit of the banks. It is simply to extract money from our society and return it to its creator, the banks. That is the true prime purpose of taxation and all these other things that we've just talked about. We need to cut through the smoke and mirrors, however, to get to that. We first initially think about income tax as being a servicing mechanism for the national debt, when we get to the truth at least, but beyond that truth is the fact that taxes are really just to take money out of our society, and the money itself is a method by which the international bankers steal our wealth and our freedom. And finally, I hope you understand that the Government of Canada is an unlawful criminal organization because it has no lawful authority to exist. Canada has no constitution because a constitution is a written document establishing and limiting the powers of government and is written and ratified by the people of the nation, which has never happened in Canada in our history.
This is a quote from the Magna Carta Canada, drafted by Eldon Warman. We Canadians have been without lawful federal and provincial governments since 1931. We have had an imposter monarch and monarchy imposed upon us since 1931, while the Crown of the City of London has surreptitiously put us into deeper bondage as a subservient colony, replacing the British Crown as our colonial ruler. We have no lawfully established constitutions for our provincial governments, nor for our federal government. The so-called Constitution Act of 1982 is an absolute hoax and fraud. The fact that it was not ratified by the Canadian people and by the inclusion of the notwithstanding clause totally negates it as a constitution or as the supreme law of Canada. We have had these unlawful federal and provincial governments encumber our country and our natural wealth with massive debt based upon counterfeit money borrowed from foreign bankers. We have had admiralty law imposed upon us by massive fraud of this government, through unlawful and ultra-vires legislation, licensing schemes, and unlawful judicial process. We have been totally deprived of our common law rights, those rights being converted unlawfully to privilege only for those willing to submit to slavery, subservience, and oppression. Judges use legal fraud and deception to entrap Canadians into their foreign maritime admiralty jurisdictions where there are no rights recognized. We Canadians are having our lives, careers, and families destroyed by the outlaw band of thugs, the CCRA, while the Canadian justice system maintains a blind eye to this piracy.